Good morning, dear colleagues. I can see that our participants are still joining us. That's why we are a bit behind. I guess we can start. Welcome to the third session on the methodological statistics framework, which were developed and recommended by the UNODC to be applied in all of the UNCAC signatories. Azat Irmanov, I'm the coordinator of anti-corruption in the regional UNODC office in Afghanistan, Central Asia, Iran, and Pakistan. I would like to remind you that the webinars are organized on the basis of the Central Asia platform for UNCAC fast tracking. Last time, we started with the A unit, the block, criminalization of the corruption crimes, and also spoke about bribery, embezzlement, misappropriation of the property or governmental assets. Today, we will continue to review this part, and also we will touch upon the measurement and evaluation of the money laundering, illegal enrichment, and abuse of powers. But to start, I guess we can speak not about only the presentation, but also from the discussion of the practical issues faced by our participants, our dear colleagues, and we would appreciate your active participation. We received 2 questions from the Law Enforcement Academy of Uzbekistan. I would like to voice the first question, which is as follows. Within the evaluation of the anti-corruption measures, we use various indicators, for example, the level of openness, exposure to corruption, and performance, and each of this has its own methodology. These indicators are used in assessing the effectiveness of the anti-corruption measures, and they are assessed by the interagency working groups. And at the same time, sometimes organizations that demonstrate positive dynamics in terms of the anti-corruption indicators, for example, transition from the so-called red zone to the green zone, simultaneously show an increase in economic crime statistics in these fields. In this regard, the question is as follows. How can we establish a correlation between the anti-corruption measures taken and the statistics of registered corruption offenses? Is there a correlation between them, and to what extent can it be a reliable indicator of effectiveness? This is a very practice-oriented question, which we need to deal with while explaining to the management the ongoing situation. That is why I would like to address it to your experts, first of all, and Ms. Salome, maybe we can start with you.
Thank you, Azat. Good morning, dear participants. If I understand correctly, you want me to comment on question number 1?
Yes, that's right. I would like you to respond, and then we will have 2 more questions coming.
Yes, thank you. Thank you for the question. I think it's very good to actually receive the questions in written after the webinars, because then we can actually address to them and try to clarify actually for further thematic areas. The importance of having more than one indicator. We cannot really say that there is a strong correlation between anti-corruption measures taking and the increase of number of cases of corruption offenses, because I think these are two very different areas that we are measuring. For example, in the first part of the question, if we talk about anti-corruption measures, which anti-corruption measures are we taking? I mean, this actually opens up a menu of measures. So in this framework, actually what we're trying to do is to try to be as specific as possible. And as you have seen from the previous two webinars, we have a number of indicators to try to understand one specific subject. And maybe you remember from bribery, we had some indicators that were constraints for the occurrence of bribery. That can be considered a measure to tackle bribery. But on the other side, we have statistics on the number of number of cases of bribery that were detected. That was one indicator. Then we had investigations, prosecutions, and convictions. So as you can see, I already mentioned a few indicators. So what are we talking about when we say corruption, anti-corruption measures? We need to be specific. We need to maybe, instead of talking about them in general, try to understand which one in particular. And then if we're talking about statistics of registered corruption offenses, again, which type of statistics are we talking about? Are we talking about reported cases, detected cases, cases that are under investigation, the number of people that were prosecuted, the number of people that were convicted? As you see, we already have many indicators there. And in the framework, what we're trying to promote is to actually look into all these indicators together to have a better picture of what is happening. Because on one hand, we can have anti-corruption measures addressing specifically bribery in the specific sector. Then maybe we need to see all the other statistics, again, reports, investigations, prosecutions, convictions, to actually understand what is happening along the criminal justice chain, let's say. So I think that the short answer is it's not necessarily about correlation or about to what extent an indicator is reliable to measure effectiveness, but rather to have a better understanding of a specific type of corruption and the specific measures that are being implemented by the authorities, and then how this translates in the, let's say, effectiveness of the criminal justice systems in terms of doing all these different stages in the process. So yeah, I will maybe stop there. I don't know if Mr. Stolpe want to jump in and comment on this question, or if you're moving to the other questions.
Thank you, Salome. We are joined by the regional representative of the UNODC, Mr. Oliver Stolpe, and knowing that he has an extensive experience in anti-corruption, I guess I would like to invite him to respond to this question as well. Mr. Stolpe, the question is as follows. The institutions or organizations that demonstrate positive dynamics in terms of the anti-corruption indicators, for example, as a result of the survey, they are transitioned from the red zone to the green zone, simultaneously may show an increase in economic crime statistics in certain fields. And in this regard, how can we establish the correlation between the anti-corruption measures taken and the statistics of the registered corruption crimes or offenses?
All right. Thank you very much for this question. It's very interesting. I mean, first of all, to build on what Salome just said, I think looking at the statistics of corruption offenses as registered by law enforcement or prosecution or the courts at whatever stage in terms of like complaints received versus offenses successfully investigated and charged to court, or whether it is in the form of conviction. None of these are good measure to establish I think, a direct relationship with the overall effectiveness of the anti-corruption drive. What they do certainly are a good measure to help establishing whether we're making progress is basically in terms of the effectiveness of the law enforcement response to corruption offenses, both in terms of like allowing corruption offenses actually to be detected, whistleblower protection, anonymous complaining, all sorts of measures that essentially encourage and make it possible for the state authorities to become aware of potential offenses. And then, of course, the catalog of offenses, like, for example, many of the countries in the region do not have a comprehensive catalog of criminal offenses criminalizing all the different offenses under UNCAC. Of course, logically, if you increase the scope of offenses, you're going to have probably more cases of corruption being reported because your criminal legislation is now adapt to capture a wider range, essentially, of undesirable conduct. So you essentially make a statement, or you are able to make a statement on the effectiveness of the criminal justice response to corruption, but not necessarily of the overall anti-corruption drive, which is quite different. And I think one very interesting set of data that I sort of observed, and I'm trying to see whether I can share my screen. Let me see. Can you see this?
It's loading.
No,
Yes, it's on.
Fantastic. Good. So what I found really absolutely fascinating here. So basically, just to explain quickly to the people on the call what we're looking at. So what we're looking at here is essentially two sets of data. We're looking here on the one hand at the corruption offenses as reported by the 5 countries, the 5 Central Asian countries. And that is the drawn through line, so the solid line. And you see basically over the years how it has evolved between 2020 and 2024. And you see, like, for example, in Kyrgyzstan, definitely an upwards trend from around 4,000 cases, peaking with almost 7,000 cases in 2022, and then a slight reduction in 2023. We don't have yet the 2024 numbers for Kyrgyzstan. But overall, when you look, there was a slight increase, right? And very similarly, I would say for Uzbekistan, so the green line. So you have essentially a massive jump, which would be interesting to understand of what that jump might have been related to. Maybe the creation of a specialized department, maybe the changes in terms of whistleblower protection, maybe changes in the criminal code as such, criminalizing more offenses or making it easier for the prosecution services to prove those offenses. Whatever it is probably not a reflection that basically we had a, what would that be, a 400% increase of corruption in Uzbekistan at that time. But we had basically a massive increase in the effectiveness of the state responding to corruption. So we have basically this jump from 2022 to 2021. And then I think it sort of like continues as an overall trend, we can say, into 2024 as a relatively consistently sort of like prosecuting successfully somewhere between 4,000 to 7,000 offenses every year. Actually, 8,000 was the peak. And then you have Kazakhstan in comparison, which has a consistent, more or less consistent number of corruption offenses that are being prosecuted successfully, somewhere around 2,000. You know, a little bit more in 2020, but essentially remaining at that level. The reason why I find this graph so fascinating is because if you then look at the dotted line, you see actually the performance of the countries against the Corruption Perception Index of Transparency International. And while we all agree that it's a highly imperfect measure and it measures a lot of things, and certainly not only corruption, and maybe not even primarily corruption, but more sort of trust in government. But regardless of that, what I found so interesting, especially looking at the Kazakh data, is that while Kazakhstan is prosecuting a significantly smaller number of offenses, despite being being the second largest country in the region, and of course being the largest economy in the region, we see a comparatively better performance against the Corruption Perception Index, which basically means two things. One is measuring corruption offenses doesn't tell you anything about, you know, how your overall effort is doing, your anti-corruption effort. And it says, to my mind at least, another very interesting thing is that from everything I have understood so far, and it is very limited, and the colleagues from Kazakhstan can maybe enlighten us a little bit more about this. From everything that I've been understanding so far is that Kazakhstan has truly a very balanced approach with a very strong focus on prevention. It means basically, simply put, less offenses happen, and that is why overall, in the perception, in the experience of the Kazakh citizens, corruption is less of an issue than in comparison, for example, with the other countries, despite the fact that overall the Kazakh law enforcement authorities are prosecuting a significantly smaller number of offenses. So I think it's really very important to understand for us what indicator do we use to measure what, and make that decision really in a very conscious way, so that we are not making the mistake of selling a set of data to tell us something that it actually doesn't tell us. So for example, if we were to look at Kyrgyzstan or at Uzbekistan in terms of the number of corruption offenses that have been successfully prosecuted, we would come to the conclusion that those corruption drives are massively effective, and why I have absolutely no doubt that they're making a very important contribution. By themselves, they're not yet actually delivering quite the progress that I think everybody's hoping for. And I think this is also, I think in some cases, reflected in the statements of the heads of states in those countries, in terms of time and again expressing both their commitment to anti-corruption, but also their expectations for the public administration to do even more and to do even better when it comes to the prevention and the response to corruption. Bit lengthy explanation, so I do apologize for that, but I thought it was an important thing to share. Thank you.
Thank you very much, Mr. Stolpe. The practice actually shows that the measurement of corruption should not be considered in only one way. If we have various trends looking towards different directions, then we need to understand that we need to take into account the local context of the country, which may go beyond the model which we have in our heads in terms of the correlation of indicators. But this is very significant. Another example from this very category, we can remember the COVID time, when the economic activity dropped and there were less interaction between the citizens and the governmental authorities, but at the same time, we were witnessing peaks in some of the countries in terms of the embezzlement cases of the funds which were allocated to support the people. So, and only after some time, in 5-10 years, maybe no one would see the correlation about these factors which we were aware of at that time, but we forgot because of the other events, and the time has passed. And from one hand, we have a better indicator in one agency, but at the same time, we have an increase in terms more and more criminal cases initiated. We could interpret this using various approaches. For example, if we strengthened the fight against corruption in a certain agency, then the criminal cases, for example, they were initiated earlier when it happened, or investigative or preventive interventions, they also contributed to a number of prosecutions and convictions. So what was done earlier in terms of the anti-corruption indicators impacted on the further statistics, for example, on an increase of the criminal offenses. So we need to be very cautious about the meaning of the indicator. We have the second question. I guess we need to take it before we go to the theoretical part of the event. So we need to clarify. So to clarify the approaches to assess damage from corruption. Often in corruption cases, different amounts may appear: the amount of the bribe, for example, or undue remuneration, and the amount of the damage caused to the state or society. Is the amount of the act of corruption, for example, bribe, equivalent to the amount of damage caused? If not, what is the proportion between them, and how should this damage be calculated? What methodologies and tools can be used by court and investigative authorities to calculate and subsequently recover damages in corruption cases? This is not only one question, this is a series of questions which may be covered by research paper, but briefly, please, dear colleagues, Ms. Salome, Mr. Oliver, what do you think about that? Maybe we can start with Mr. Stolpe.
Yes. I was frantically trying to find a very interesting study that was done by the STAR initiative some years ago about the quantification of bribery in terms of damages. And I would strongly recommend to anybody who has a deeper interest in this matter to take a look at that, because there's some very interesting ways of how essentially courts across the world have been confronted exactly with that specific question of how to quantify the damages, which could be quite important, especially for cases of civil cases that you might want to bring against companies that have been responsible for major bribery schemes, and you want now to recover those. So there is some body of knowledge that I think we can go back on the specific issue of quantification of damages. There is, of course, also the bigger issue of quantification, which I think is the invisible and erosive part of corruption, which I think cannot be measured, at least I would not know how to, in economic terms, but which are which are to be measured in social terms. And it is really that corrosive nature, because in many ways, in countries where especially low-level bribery is still in existence and frequent, and citizens are quite often confronted either explicitly or implicitly in their interactions with public servants that the payment of a bribe of some sort or some other incentive would be required in order to get what they want from the public administration. That defines the relationship that the citizen has with their state, whether it perceives and experiences the state as a protector, or whether it experiences and perceives the state as a predator. And I think that is very important for the general sense of social cohesion, of the strength of the society's fabric to be able to work together towards an improvement of everybody's living conditions. And I think, therefore, I think the corrosive effect of that kind of corruption has long been underestimated. I think we have in general seen a very strong focus on this kind of like, you know, the elitist corruption, which of course, needless to say, at some point needs to be addressed by a society. But I think in terms of the support that you would like ideally to be able to have in your society and that you need in order to successfully eradicate all forms of corruption, I think that that focus on this low level of corruption, which eats away not only in economic sense from the income of households that are spending some of their money essentially on paying bribes, but that eats away essentially in the trust that people have in the state as a whole, and of course in the government specifically. So I think the damages need to be very much also seen from that angle, and not just from the economic angle, which is of course very, very important.
Thank you, Mr. Stolpe, for this comprehensive answer. Salome, any comments?
Yeah, I mean, I just wanted maybe to add that there is a very simple way of trying to come up with a figure of the size of the damage in economic terms. And we actually get it through surveys. If a country is conducting a national survey to measure corruption, you measure different aspects. And very specifically, you can measure the experience of bribery. And when you are asking about the experience of bribery, first of all, you need to establish that this person, the citizen, was in contact with a public official. And then you need to have some follow-up questions about this interaction. So you need to understand if this official asked for money or a gift or a favor. Actually, we don't use the word bribery. But then if that was the case, if a person, a citizen was asked by a public official to give something in return, to maybe expedite a procedure or a license or some public procedure, once we know that there was this request, then we can ask about what was the economic the economic request in terms of money, the economic value of this request. And we can estimate the size of bribery in terms of the monetary value of this phenomena. And I mean, the countries that are conducting national surveys to measure corruption, we see this estimation. And usually what we see is this figure, let's say the economic value of briberies, this is like really petty corruption, but let's say the size of the value of briberies in as a percentage of the gross domestic product, just to have an idea of the size of the damage. Usually, I mean, I've seen experiences in countries that actually have population surveys on corruption, but they also have business surveys on corruption. So they go and ask businesses. And in that way, we have, let's say, a bigger amount of a better idea of the economic damage of bribery if we're able to conduct these two surveys and to have these two figures from these two different groups, businesses and surveys. And I see that if I may. Azat, I think we're receiving some comments, very interesting comments in the chat. One colleague was saying, good morning, maybe as a result of appeals or reports of citizens and employees, increased detection of corruption and interaction with law enforcement agencies to initiate criminal cases. Perhaps the preventive work was not carried out properly, which showed the growth of criminal cases. And this is very interesting because, again, we cannot just look at these statistics of the number of cases that were detected or that are under investigation in isolation, because maybe there was a transformation there. Maybe, like Mr. Stolpe was saying, maybe citizens are increasing their trust in government and they are more open to report. And that's why there are more cases under investigation. But then we also need to look at, for example, the experience of corruption, for example, in the case of bribery. If we go through a survey and we try to estimate the number of people that actually experience, for example, a bribery, and if we compare that number, that is the actual size, the actual number of experiences, if you compare the number of experiences with the numbers of reports or investigations, there must be a very big gap there. And that's why it's very important to understand and see these two indicators together to see that even though maybe authorities are detecting more and are investigating more cases, maybe there is still a gap between the actual experience and the number of cases that actually reach the law enforcement institutions. But this is, I guess, one of the discussions, and I see more questions. Over to you, Azat, to follow up on that.
Dear colleagues, thank you very much for being so active, for your questions. I guess we will try to tackle them after the main presentation. It's a very pleasant discussion, but we already spent 35 minutes. Now let's move to the lecture. So the head of the Information Center of the UNODC now region, Ms. Salome, over to your presentation.
Thank you very much, Azat. Good morning, and I see that we have a larger number of participants today. So I think it's worth just to mention very briefly some context about this framework for all of them to know. Next one, please, Gulnar. So this statistical framework was developed by UNODC after consultations with more than 80 member states. We had 3 rounds of consultations. The institutions that provided more feedback to this framework were anti-corruption authorities. The framework is available in 5 languages now, and you can access it through this QR code. The framework is actually a menu of indicators under specific thematic areas. Next one, please. And the framework contains more than 150 indicators, and it's kind of a menu for national authorities to choose which thematic areas are more relevant for them to understand and monitor and measure. So UNODC is not expecting countries to measure all these indicators, but rather to review the framework, select the most important topics that are relevant for the national anti-corruption policies, and start collecting information about these topics following the suggested indicators in the framework. This is work in progress, and actually it's not only about collecting data. What we are trying to promote is to have discussions at the national level to first decide which topics are more important and then to try to understand what data is available out there. Because in the framework, we include indicators that are coming from different sources. Some of the suggested indicators might come from surveys. Other indicators might come from administrative records that an institution already have, but they maybe need some transformation to actually make sense from the statistical perspective. And we actually have other indicators that are more qualitative because they are related to the legal framework. So this is just a very brief overview. Next one, please. So for those that are not familiarized with the framework, we have 3 dimensions, and actually these dimensions mirror the UN Convention Against Corruption, the UNCAC. So we have 3 dimensions. First of all, the areas that are criminalized according to UNCAC. Then we have a second dimension that is actually about preventive measures. And third one is about the environment to report and address corruption. And we have different type of indicators, as you can see from the figure at the bottom of the slide. We have indicators that are direct measures in some cases, because we cannot really measure all the thematic areas directly because it's quite complex, as you all know. And then we have indirect measures, because based on the discussion earlier, we can see that there's no single indicator that can explain what is happening in relation to a specific type of corruption or a specific preventive measure. You need to have a combination of indicators to try to understand each area or each topic in a more comprehensive way. So we have, in some cases, indicators of perception. And I have to say, at UNODC, we were reluctant to include perception in the framework, but we faced huge push from countries to actually include perception because they think it's important to monitor. But of course, it's indirect and it's not necessary. I mean, of course, it gives us some idea of what is happening in terms of perception, but as Mr. Stolpe already showed, the perception, the gap between perception and the actual number of crimes, it can be very high, and it's not really telling us much about the actual size of corruption or about the effectiveness of the criminal justice system to investigate and convict people because of crimes. But again, it's there as well. So we also have indirect measures that are called risk indicators. Under risk, we have indicators that measure opportunities for, let's say, committing some specific types of corruption. And then we have other indicators that are also on the risks that are more about the constraints. So measures that are in place to actually deter these behaviors from happening. And finally, we have indicators that speak more about the response of national institutions. First of all, the jure indicators. So this is the legal framework. And then we have de facto that are more those from the criminal justice system. Next one, please. So under each dimension, we have thematic areas. In the previous webinar, we already checked or reviewed indicators on the bribery and embezzlement, misappropriation or diversion of property by a public official. In this webinar, very quickly, we will go through money laundering, illicit enrichment, and abuse of functions. Next one, please. And so these are the indicators under money laundering. We have 15 indicators, 1 under perception. Then we have 3 under constraints. We have 5 de jure indicators, and then de facto indicators, also 6 actually. We're gonna see each one of them very, very quickly to give you an overview of what the framework includes to monitor money laundering. But one thing that I guess it's good to highlight is that the indicators that are included under money laundering are also part of, are connected to other efforts linked to money laundering by other international organizations. And the reason because of us including these indicators is because we want to connect with existing efforts to actually from different organizations have a bigger push for countries to actually engage into collecting this information and publishing it to show their interest and willingness to work on this area. So next one, please. Regarding the sources of these indicators, you can see we have 3 different colors. The yellow one is the first indicator, which is about perception. And this would come from a survey. And like I said, there was a big push from countries to include perception. But I think in our discussions internally with experts, this indicator on the perception of corruption in the financial system in particular had, let's say, some concerns. In our discussions, we had concerns about the challenge of actually measuring these indicators through a survey, because not everybody really understand what the financial system is, especially when you interview citizens. Maybe they think about banks in particular, but maybe they don't see what the financial system actually includes in a country. So what we're saying is this is a particularly challenging indicator that perhaps it's going to be biased and it's not going to tell us much, but it's there. It was included. Then we have the blue indicators, the ones that are highlighted in blue. These are coming from administrative records. That means some institution is already ideally having information on these indicators. And then finally, we have the ones in green that should be available in the legal framework. Now, the next one, please. Some reflections about the indicator on the perception. So the indicators is perception of corruption in the financial system. This should be measured as the proportion of persons who perceive that the financial system is corrupt. Ideally, we should have disaggregations by sector. So, for example, we included here the banking system, of course, real estate and customs, but these are just suggestions. And actually, I have to say that this statistical framework is, like I said, the menu of indicators, but we also have, let's say, an annex which details, which actually explains the metadata. So it provides the definitions used in the indicators. It provides the method for estimating each indicator. And it includes, for example, the relevance, the policy relevance of each indicator, and you will find more information there. We don't have that document available in Russian, at least not yet. It's work in progress, but hopefully we will be able to finish it soon so you can actually review it and see with more detail what each indicator is about. So as I was saying before, this indicator is particularly difficult to measure. Perception is always subjective, but in this case, it could be even more. Again, because of this gap of the perception of the corruption in the financial system, and in particularly because this perception about, or negative perception about the financial system is not necessarily connected with the size of this phenomena of money laundering. It's not necessarily connected, but again, countries wanted to measure perception in relation to the financial system. Next one, please. So the 3 following indicators, as you saw from the previous slide, these are risk indicators. These indicators talk about the constraints. So these are mechanisms that ideally are in place to actually monitor the risks related to money laundering. This indicator is addressing risk gaps. So the indicator reads number of gaps that have been addressed since the last evaluation by an international peer review body or since a national risk assessment. In Central Asia, we see that countries have received a number of recommendations by FAFT. And in here, in the framework, we are basically suggesting to report their efforts in answering in response to these evaluations. So it's just an opportunity to show, like I said, if the country is equipped and is actually working to address these gaps. So identifies weaknesses in the anti-money laundering controls, support these risk-based policy designs and resource allocation, and enables proactive prevention of money laundering. This is what we think that these indicators informs to, and the reasons why it is important to measure it. Then we have some challenges for governments to measure these indicators. This requires having good and comprehensive data from diverse sectors. This also requires a lot of work to be able to monitor the evolving typologies that make these risk gaps dynamic. And usually another challenge is that interagency coordination is not necessarily always in place to actually be able to get the information in a timely basis, and also in the level of detail that should be required to understand these gaps and the risks associated to these gaps. Now, the next one also, please, A3.3, it's again an indirect measure on the risk, and it's also about the constraints. And this is about the supervision on anti-money laundering regulatory framework. And this is the number of supervisory activities conducted regarding institutions that are obliged under the anti-money laundering framework. And this is, again, all about oversight and about the compliance of, in this case, FAFT recommendations. Sometimes what we see is that in order to find this data, we need to actually go and find the reports by FAFT, and we need to go through the reports, and the recommendation of this framework is actually to create these national repositories to actually show, for example, these key indicators about money laundering in a, let's say, accessible format for experts and other organizations, other institutions, and even media, to show the efforts that the national authorities are doing to actually try to put some constraints about money laundering. And then we have another indicator, the last one, under constraints. Next one, please. Yes. So this is a number of transactions that were frozen. And yeah, this one, together with the indicator on the suspicious transactions that will come later, are key actually also to show the preventive efforts for supporting investigations of money laundering. And it's an indicator of how responsive the country is, but it requires efforts to actually be able to collect the information and publish it on a regular basis. And I guess we're going to review more in detail the legal framework that is required to actually have this information available in the next part of that. I think, Azat, you're going to take over this, right? To the ones under the jure. Over to you then.
Thank you. So, colleagues, we have moved to the quality-based assessments of the current legal systems. I think this is the wrong presentation, so let me use, okay, this is the slide. Okay, this is okay now. Okay. The main idea behind evaluation of the legislation is that statistical framework is recommended to be used globally, and one of the main principles of statistics is the comparison of the data, comparability. So the indicators which we are using, they need to have the same meaning for all of us, and harmonization of the national legislation with the single standard of UNCAC is the work which also includes the indicators which we are measuring to have the general uniform meaning. So we could look at it in the context of creating the general unified platform. Speaking about the criminalization of the money laundering, here we use the Article 23 of the UNCAC Convention, which regulates the money laundering. And we also need to analyze the national legislation to understand whether it covers all of the elements provided for in this article. So we are saying that we need to check all of the phrases which are meaningful. I tried to generalize what is important, but the Article 23, I would like to remind you, requires to criminalize the actions related to the transformation of the property which was bought illegally, including as a result of the corruption crime. This should be part of the criminal legislation of the country, even if it is a passive money laundering with the use of the property. If the person is a part of the scheme, directly or indirectly, this should also provide for the criminal liability. So this goes for the different types of assets. Participation, accomplice, different elements. And also what is very important, we can compare all of the indicators to the convention as a starting point. As I mentioned last time, we can use the results of the first review cycle, after which the recommendations were made, and from that point of time you can check what changes were made up to date, and this approach will save you some time. The next indicator, transparency of the beneficiary ownership. This is a crucial element in terms of preventive anti-corruption measures and a part of information which is required for the investigation of the corruption. And the task here is to provide a clear understanding between all of the stakeholders to whom this property belongs. If the individual is involved in the corruption scheme or at the risk of committing corruption crime, then it is meaningful for the purposes of prevention and the investigation as well. That is why convention sets up the requirements, how to identify the clients of the financial institutions and non-financial institutions as well. And if you look at the Article 14, you will see a broad explanation of the individuals involved in the financial transactions, including informal service delivery on money transferring through the borders. So we need to be very cautious in terms of possible participants or individuals involved in taking money through the borders. And we all need to understand whose funds are being transported, for example, whose funds are crossing the border. And this information could be obtained only in case we have the system to collect the data and to identify the beneficiary owners. And after this, we need to register the suspicious transactions, taking the further actions. They should be reflected in the national legislation with the use of the bylaws most frequently, because this is related to the actions at the micro level, at the level of the financial institutions or companies providing various services in relation to a certain sector or non-financial sector, as I mentioned before. But anyways, this is everything related to the technical conditions which supplement carrying out the transaction. The next component which should be evaluated and compared in terms of the legislation, also a very important element, anonymous cash transactions. We'll all understand that cash is the best way to conceal illegal proceeds, and the most popular way, which was used in past, but now it's more and more restricted because it's very difficult to have the cash transaction. We create additional barriers to conceal the corruption proceeds. In a modern world, you know very well that transactions related to a big amount of cash is always suspicious, and there is a reason for that, of course, because always this is to some extent is related to an attempt to not to pay taxes or to money laundering or maybe other purposes which are usually illegal. Here we also look at the way and to what extent, in terms of the detail, we have imposed certain barriers on the cash transactions. The next element is about virtual assets. This is a relatively new type, but still, just with the virtual assets, Bitcoin, for example, once they were created, it was clear that this is the most promising asset in terms of the transactions in criminal fields, because it's very hard to trace. That's why we need to undertake measures to impose, once again, barriers, impede the opportunities given the options which are offered by these currencies, let's say. And we need to understand that the present barriers, they are already outdated because the technology is far away and moved forward in comparison to the previous years. So there are certain tasks we need to perform in terms of the identification of the individuals having transactions with the virtual assets, because we will be able to ensure the competent authorities with the necessary information and understand who are those who participate in these transactions and who are doing this legally or illegally. So the national legislation should be compared to the international standards. First of all, UNCAC which is a prerequisite to what is happening today. So, and the availability of the mechanism to exchange information, one more key element without which we will not be able to take measures, for example, to trace stolen assets because of corruption or asset recovery. For example, all of these mechanisms, they should be in place and operational. We need to assess to what extent the current legislation is in compliance with the UNCAC standards. Why is it crucial to run this overview regularly? Sometimes you become blind when working with the same text, with the same wording. You can miss some elements which are very important. So periodical reviews of the national legislation serves as a factor which helps us to fresh up our knowledge, which we received from other sources of information. For example, if we speak about the virtual assets and technology development and the use to conceal criminal proceeds, periodical review of the legislation, once again, I would repeat myself, is a must. For the other users or those who are not involved in the anti-corruption, the part on the evaluation of the de jure mechanisms allows to explain the dynamics or the quality of data or dynamics of the indicators which we have in terms of the qualitative indicators. Then it becomes clear why in one field we have less or a lower level of the quantitative indicators than in other countries, which have a similar economy, the number of population, or the average crime statistics. So the specificity of legislation helps us with understanding the context where our anti-corruption bodies perform their functions. This is the end of the de jure measurement, and we go to the response measures. Salome, over to you.
Thank you. And I have to say that we have to run to another meeting, but yeah, I don't know why we have a duplication of meetings, but I think before I was talking about this indicator already. And for the money laundering indicators, as you know, this is an essential indicator in terms of compliance, in terms of risk management, and in terms of building credibility at the international level. It's very, very important to have this indicator in place. First of all, at the national level, the number of suspicious transactions is very informative for regulators. It's very important for the financial intelligence units to actually understand where are the threats taking place, in which sectors, in which institutions, in which regions are these happening, and how what techniques are being used for money laundering. Now, so this indicator is basically useful for understanding the scale, the size, and the nature of the risks. So where are these suspicious transactions appearing? And the importance, of course, for having this indicator is because once there is a suspicious transactions identified, these may trigger investigations and prosecutions later on. And actually, this is the starting point to be able to trace illicit financial flows, of course, that usually go across borders. Now, this is also important to understand, to have an indication of how effective anti-money laundering controls are in each country. And actually, if we see, for example, in a country that there is a low number of suspicious transactions, we need to understand why is that. Is it because there is a lack of awareness or training? Is it because the internal controls are weak? Or is it because really it's not many, there are not many transactions going on, and maybe they are using criminal networks might be using other avenues to actually do this activity. But it's definitely also connected, like the previous indicator of the frozen assets and the other risk-based indicators. This is also essential, and it's connected to the international standards and to the work that FAFT reviews in all the countries. And as you know, this is very much looked into detail, and the low levels of compliance or the failure to measure or act based on suspicious transactions can have implications in terms of, for example, the gray listings. So it's definitely the reason why we included it as one of the key indicators in this area of money laundering. So yeah, I think we believe that it's also important to measure this indicator because like I said at the beginning, it can build on international credibility. It can show the integrity of the market. It can improve the trust or the confidence of investors in a country, and it shows good reputation in terms of the financial management of the financial system at the national level. So yeah, this is basically one of the key indicators in the framework. Then I think we can move to the next slide. And the next slide, I believe we included all the de facto indicators. I think in the first part, we were already discussing about these indicators that are response indicators. We call them de facto. These are about the work. I was going to say effectiveness, but it's more about the work of law enforcement in terms of investigations, prosecutions, convictions. I think I only included these three. And it's good to monitor these indicators just to see how active are the criminal justice system in terms of investigations, prosecutions, and convictions. The recommendation, as we were saying at the beginning, is not to look at these indicators in isolation, but rather to have them available to see what is happening in each phase. But more importantly, to collect these data on a regular basis to be able to monitor the trend every year, and to show the pattern of these different phases within the criminal justice system. We cannot straightforward say that this show effectiveness, but again, if we have a comprehensive understanding of the phenomena, only once we have all this information together to see how perception has some relation with the constraints, to see if the country is equipped, legally speaking, to actually tackle all these issues, and then to see what is happening in terms of, in this case, let's start with suspicious transactions, and then the actual response from the authorities. We also have another indicator on the response. I think it's the next one is about administrative sanctions. And this is just to have an additional information that is not necessarily criminalized yet, but it definitely, it's an indication of responsiveness to this phenomena in the country. And yeah, I see we have a final one that is about the assets recovered for money laundering. Of course, this is what we would all like to see, but yeah, we don't see actually many countries having comprehensive information on these indicators. But these the assets recovered for money laundering, this is the ultimate indicator to show actually the effectiveness of all these efforts, legally speaking, and in terms of investigation and prosecution. Many challenges to get there, as you know, legal challenges across jurisdictions, many challenges in terms of be able to actually once the assets have been identified, to actually get them back, because there are also the challenges of some avenues to actually hide them or somehow make them disappear. So many challenges to actually be able to get this information. So just some final reflections about money laundering indicators. So these can show, the indicators that we included in the framework can show us specific areas that are vulnerable or that are underperforming. If we are able to see all these indicators, we can perhaps have a sense of the effectiveness, the anti-money laundering effectiveness in the country end to end, from identifying through suspicious transactions to all the way to the asset recovery. It can also help countries to understand the gaps between the legal framework and the actual enforcement. It's also useful to identify risk sectors, different types of typologies, and the trends, how these typologies trends change over time. And then finally, to see if having data allows for better mutual evaluations and better informed decision-making in cross-border cooperations. So yeah, with this, I think I will stop. And then we have, maybe we can take some questions here, Azat, because I saw that there were other questions in the chat.
Yes, thank you, Salome. We have a question which was partially touched upon in our presentation. To what extent do we need to use the data of the Corruption Perception Index as a targeted indicator in the strategic document of the country? Do you want to comment on it, Salome?
Yeah, I think it's a very good question. I think we actually discussed a little bit on this question in the webinar, in the first webinar, in webinar number 1, because this indicator is, as we all know, the most popular, the most widely used indicator to monitor corruption and to inform corruption. And it's very accessible. Every year we see the results of the index, and we see this chain reaction in all the countries. We see how if the rank of a country, the ranking of a country improved, everybody's happy and it's showing off the good progress. But then if the ranking it's looking worse, then there are questions about how to improve this ranking. And I'm saying this because the ranking is really based on perception, but it doesn't speak much about the actual how can I put it? The actual problem. It doesn't tell us anything about the size of the problem. We don't know if corruption is going up or is going down. And we don't know because we don't even know what type of corruption are we talking about. I mean, we know that corruption is difficult to define. There's no single definition of what corruption is. In the convention, we have specific behaviors under specific names, and they're all under corruption. And this is because the way that corruption manifests is different. It's not the same to have someone bribing somebody else than to have someone abusing functions or becoming rich illicitly. There are different types. So the perception, the index on the perceptions of corruption is very useful, is very good for raising awareness, but it's not telling us literally nothing. It's not telling us much about what is actually happening in terms of corruption, in terms of the size of corruption, in terms of the type of corruption, in terms of in which sector are occurring types of number of different types of corruption. And I'm saying all this because we like the indicator. We think it's great for raising awareness, but in reality, it's not going to help us to understand how corruption is occurring. And more importantly, it's not going to be able to inform us if the preventive efforts are working, because through this index, we really don't know anything, for example, about what the country is doing to prevent specific types of corruption. So it's very limited what we can get from this indicator, and we definitely do not recommend to use this indicator only. And actually, the reason why UNODC started working on this statistical framework was to have additional information that could help countries to really understand the complexity of dealing with corruption. So to make it short, it's ideal to use other indicators, not only this indicator, to have a better understanding and better monitoring of the efforts, and also a better understanding of the effectiveness of the efforts. Over to you.
Thank you. So indeed, if we take only this indicator, this is not informative. It's better to use a mixture, a combination of various indicators to be able to better understand what changes are happening. So this is only about the perception of the corruption. But another point, there was a research last year on the website of the UFPO, U4, it was the name. So they mentioned that in communication campaign on prevention corruption may impact on the perception of the corruption, but in practice, nothing has changed, for example. So, colleagues, we are far behind the schedule. We planned to take only an hour, but we failed. That is why I would propose to stop it here at our A4 indicator, and next time to start with it, because we will try to cover this indicator in the next lecture, maybe briefly, but to touch upon each and every indicator so you won't have any questions. And please do prepare your questions in advance. If you share the questions with us, we will be able to prepare to the questions and to provide answers quickly. I hope that we will achieve our common goal to better understand the way we could use more efficiently this methodology in practice to measure corruption. Dear colleagues, thank you so much for your participation. This is the end for today. We will be waiting for you next time according to our schedule. Thank you. Bye-bye.
Thank you. Bye.